Morning, everyone. Thank you for joining us for Minnesota Matters, where we discuss state law issues that impact banking. My name is Tess Rice. I'm MBA's General Counsel. I'm joined by Teresa Kubas, our Government Relations Manager, our Senior Government Relations Manager, Tom Boswell-Healy, our Associate Counsel and Compliance Consultant, and Keith Johnson, our Associate Counsel. Teresa's going to kick it off this morning to talk about what's new in St. Paul. Tom's going to talk about some foreclosure issues, and Keith has a couple new cases that we want you to know about in the courts. And then if we have any time left over, I have some fraud Q&As that we could talk about. If you have any questions, just put them in the chat and I'll be monitoring that. Teresa, you ready?
Sounds great. Good morning, everyone. I do not actually have as much to talk about this month. The last time we met for Minnesota Matters was the legislative wrap-up right after May 17th, which wasn't truly a legislative wrap-up since the legislature hadn't completed their budget work. So Governor Walz called the legislature back into session on June 14th as his monthly extension of the peacetime emergencies. And at that time, they had intended to finish the budget work, hope to get it done fairly quickly. But the true deadline was June 30th, and that's how long it took. It took till June 30th to get that budget bill, all the budget bills done. There is no special sessions as of right now. There is a possibility of one in September. There was that huge influx of money that came in for COVID first responders for bonuses. So the legislature, there's 5 members from the House and Senate and the administration currently right now trying to figure out who should be getting those bonus dollars. If they can come to an agreement, I believe they come back into special session, but that remains unknown at this point. So the first time they would come back is possibly September. Next year they are still working on redistricting. So that's something that's still in our minds. So we are continuing to watch to see what the lines will look like next year for the elections, who will run, who won't run. One thing I wanted to note, and I know that somebody will be putting it in the chat, is last Monday, our legislative summary was emailed out to everyone. That is the best information for everything that happened in the legislature last session, talking about all the bills that passed and became law, things that didn't pass, and then things that could possibly be coming up again next session. So again, that was sent last week. It will be in the chat now. So take a look at that. I know that as the numbers continue to rise again for the Delta variant, a lot of people are starting to talk about mask mandates, peacetime emergencies. Everything that I've heard is that the governor does not intend to reinstate his peacetime emergency powers. He would like the legislature to kind of look at what they can do if something needs to be done, and then leave it at a more localized level for mask mandates. I think also going into next year being an election year, I think a lot more things will be very politicized, not that it hasn't been already. So I know that they are starting to look at being more of a local level. So everything is very much, you can, if people want to, businesses want to have masks optional, I think it's really hard right now to mandate it. So those are some of just kind of the touch on some of those items. Then a couple of things from the legislative summary that I wanted to bring up. In the tax bill that passed on June 30th was the PPP, tax conformity. That is one that was supposed to be done, was hoping to be done early on in session. So that did get done. So all those businesses that did pay some taxes on their PPP loans should be getting refunded from the Department of Revenue. Also within the tax bill was also some language on property assessed clean energy. It's different than the actual pay statute. There's a pay statute right now in law, but this one was actually brought by the city of St. Louis Park. They are looking towards their clean energy and energy efficiency within the city. They have some dollars there. They thought it would be a good idea just to put something into law that they can help fund those that if somebody wants to petition the city, that they can have those dollars and then assess it on their property taxes. So very similar to the current pay statute. It was just a roundabout way of doing it, a lot simpler. That ended up, and they initially intended it for residential, small business or businesses and multi-housing. We really focus it on commercial property because we know that there's a lot of problems with lien position, especially on residential, not having the ability to repay within there. So the language was written to only commercial properties and multi-housing properties, and that we also had them, requested that they put in a notification to lenders that this is coming about, and which gives lenders the ability to really talk to their customers if it's something that's not good, or just kind of have it on your radar. So it's not something you find out down the road. Tom's going to talk a little bit about the eviction moratorium phase out and kind of what that means for foreclosures. That was one of the areas that the governor had held on to his peacetime emergencies, was because of the eviction moratorium. So when that language got included into the housing bill, the governor did feel that he could give up some of that power. The farmer lender mediation sunset was pushed out to 2027. I believe we talked about that in the last call. There was some legislators that wanted to add 30 days on to the process as it sits right now, making it 120 days or longer. But the Republicans did not want that to go through, and we worked really hard with another coalition. And so while they didn't add the 30 days to the process, they did push out the sunset to 2027. The Republicans felt by pushing out the sunset, it hopefully gives that issue to go away for a little bit. The last issue I'm going to talk about, which will go into Tom's conversation, is the check account opening statute 48.512. You should have received a bulletin about it not too long ago. This one was passed during the regular session and did go into law on August 1st. We've had lots of conversations with bankers over the years, specifically about 48.512 and the inability to open certain bank accounts for people that have had bad checks in the past. With the overabundance of conversations about unbanked and underbanked, this is one that various nonprofits have wanted to look at. It's a way to get, their thoughts were it was a way to get people into bank accounts. We kind of went back and forth whether that was truly the case, since there are nationally chartered banks that were able to still open up these accounts. We ended up working with others on this language that kept the current language as is. However, if you had a program or wanted to implement a program for unbanked, underbanked to get them into bank accounts, therefore you wouldn't have to follow the current statute. So it kind of gives some leniency to those that wanted to follow the statute, and then some that others that did want to implement a program to work with the unbanked and underbanked. Also within there was the $4 fee for checks for the person that received that check. That amount went up to $10, and Tom is going to talk a little bit about kind of disclosures with that $10 as well. So at this point, those are the few that I have. Again, there's a lot of information within the legislative summary. Take a look at it. If you have any questions, feel free to reach out to us on that. But that's all I have. I will pass it over to Tom.
All right. Good morning, everybody. I'm Tom Boswell-Healy. I'm talking about just three topics this morning. First, about 48.512. As Teresa said, the amount that you're allowable to charge on those dishonored checks is increased from $4 to $10. And just in relation to Truth in Savings Act, as you know, a change of terms requirement, a change of terms notice rather, is required on certain changes made to an account, one of which are fees that are disclosed at account opening. And certainly this would be covered if you look at the commentary where it talks about what types of fees are covered. One of the items there under D, in the commentary, it talks about fees associated with checks returned unpaid. So it seems pretty clear to me that that's covering that increase from $4 to $10 in that item. So if you are looking to increase that, before you start imposing that on anybody, you should do a change of terms notice, which can be a statement stuffer, it can be a statement message. The format is not too, there's not too many requirements on a particular format. Just make sure that it gets out 30 calendar days in advance of when you're going to begin imposing that fee. The change of terms notice should also include the effective dates of that change. And those are the big pieces on that. If you have any questions on that, feel free to let us know. The next topic I was going to talk about that Teresa mentioned too was the Minnesota eviction moratorium, in which currently that law has essentially 5 dates where it's phasing in and out, phasing out protections rather on eviction. And I was listening to some information put out. I was talking primarily about tenants, but they also touched on foreclosure, and there's some questions as to when a bank, if you're going through the foreclosure process, when exactly you can provide the initial foreclosure notice and begin foreclosing, or actually at the end of a redemption period, send that notice that you're going to evict the persons that are in the property still through that possibly extended redemption period. So you have that, and it looks like the tenant's eviction to me, it doesn't really cover that foreclosure period, but there is some discussion as to whether it impacts those dates. Kind of the big one to remember for these is October 12th, 2021. That's when most of the protections expire. When you're dealing specifically with tenants, the only one that really hangs on is if the tenant has a pending application for emergency rental assistance due to COVID-19. Then you have some limitations there. So in addition to the foreclosure issues, obviously, if you have some commercial borrowers that are landlords, if they have some issues on that, the Minnesota Housing Finance Authority has a good webpage discussing this, has frequently asked questions. They also have an image that I think a Minnesota Homeline actually put together that talks about the dates and what different protections go away on each date and when. So that's a good resource there. And then the last thing that I was going to talk about was the Juneteenth issue, where on August 5th, CFPB just came out with their interpretive rule. It's effective as soon as it's published in the Federal Register, which it hasn't been yet to date. Usually there's about a week or two delay in there. But since Juneteenth already happened, June 19th, and actually Friday, June 18th is when it was observed this year, the first year. And this was signed by President Biden in the late afternoon of June 17th, so there's not much time for banks to do that. What this did was create an issue around business days, as I'm sure you're all aware. So Friday, June 18th, when you woke up that morning and found out that it was no longer a business day, caused some concern for banks and how to deal with that. And it's important to remember the interpretive rule only covers closed-end right of rescission and the TRID timing. And the basic way that they've addressed it is that anything that was provided before June 18th, so June 17th or earlier, then you work under the same holiday framework that was in place at that point. And then as of June 18th, you work with the holiday framework that starts with June 18th being a federal holiday. So if you had to provide a disclosure, a TRID disclosure, say on Thursday, June 17th, then you count the business days as if Juneteenth never occurred. If you provided a loan estimate, say on Friday, June 18th, then you would treat that as a federal holiday. You wouldn't be able to count that, so you'd have to start your calculation on Saturday or Monday. I think there's still some question exactly on, since Friday, June 18th was the observed holiday, you can count June 19th for this year as a business day. That's pretty much what I have. One kind of added note on there with the Juneteenth, there are some other regulations where business day calculation comes into play. Certainly, if you were able to follow a similar framework that the CFPB has set out now a month and a half later, if you were able to do that at the time, then you should be good and be able to export that rationale for how to use the dates in those other situations. And that's what I have.
Tom, I had a call with ABA yesterday about that closed-end, open-end issue, and they've talked to the CFPB about it, and I don't think the CFPB, or they don't think the CFPB meant to only apply this to closed-end, even though that's the language they used. So they're trying to get clarification from the CFPB that also applies to open-end loans.
Yeah, it makes no sense that it would just be closed-end, but that's, they never mentioned open-end in the entire interpretive ruling, and they only cite the closed-end portion of the rule when they do it. So yeah, they should definitely clarify that, and hopefully they will. Maybe they'll get it corrected before it gets into the Federal Register.
But mainly the message from the CFPB was whichever way you did it, whether you chose to treat it as a business day or not, you're okay, right? But there's some concern, I think, still from the secondary market about it. So
Yes, and also, they made the point repeatedly in there that if you provided more days than were required, you're fine as long as rescission or the TRID time frame. So you can always provide more than is required under the reg. You just can't provide less.
Okay. Got it. All right. Thanks, Tom.
Thank you.
Keith, are you all set with some interesting cases? We're going to decide if those are interesting, by the way.
Yeah, as interesting as they can be, I suppose. Well, I just have a couple cases to talk about. So the first case is Anderson v. MidFirst Bank, and actually both of these cases are foreclosure related. So in this first case, Anderson had a mortgage with MidFirst Bank after buying her home in 2008. Eventually, she didn't make payments starting in July 2012. And the bank tried to foreclose a couple times, and for some reason they didn't go through. But eventually it was foreclosed, and the bank purchased the property in January 2018. So following the 6-month redemption period, after that expired, Anderson didn't redeem it, and a company called Collection Resources redeemed the property from the bank, and then it eventually was conveyed to a person named Kent Rossman. So Anderson then sued the bank, Collection Resources, and Rossman. Eventually, the bank won summary judgments, and the claims against Collection Resources and Rossman were dismissed. So now Anderson appealed, and that's what this case is. And there's really two parts to this case. And so the first part is the claim from Anderson against the bank, and that has kind of two issues. The first issue is whether the bank properly served Anderson with a notice of the default, and whether the bank improperly demanded payment of what was claimed to be previously excused monthly payments. The second part is the case of whether or not Anderson has standing to sue Collection Resources or Rossman. So for the first part, the rule in Minnesota is Minnesota Statute 580.032 subdivision 4. And it states that in a foreclosure by advertisement, which is what this case is, it says that mail to notice is deemed given upon deposit in the mail first class, postage prepaid, and addressed to the person requesting a notice. So it's important to note that in this case cited in this decision, that it, in the absence of proof to the contrary, you just assume that mail properly addressed in postage with postage prepaid is duly received by the addressee. So you just assume that it's received by them, even if it's later returned, or you don't know for certain whether or not the person actually received the notice. Because in this case, the bank sent Anderson a notice by certified mail that she must pay her past due payments, late charges, fees, and it also sent her mortgage statements from April 2017 to July 2017 before starting foreclosure. And so the post office attempted delivery, but the mail went unclaimed, and eventually it was sent back. And Anderson acknowledged to the court that notice was delivered to her home. And so her own admission established that the statutory notice obligation was met in this case. And it's unclear why the mail was not received by her. She probably just left it in the mail. But the facts of the case don't really say exactly. So we just assume that perhaps she ignored it. And as for the payment demand, Anderson was claiming that the previous payments for the multiple years where she was in the home and not making any mortgage payments were excused, which there's no evidence that they were. And in that situation, the notice clearly stated that Anderson owed past due amounts, and that by requesting those monthly payments, the bank complied with the terms of the mortgage, which stated that the bank can demand payment in full, in the full balance in the event of default. So the summary judgment motion that was granted to the bank in the previous decision was affirmed by the court in this case. And as for the second issue with the standing one, standing is just whether or not a person actually has the right to sue another party. And in real estate, when real property is sold in a foreclosure, the mortgagor can redeem the property. And in this case, the time period was 6 months. So after that 6-month period expired, the sales certificate, when it's recorded, is a conveyance to the purchaser, and the purchaser's assignee of that real estate. And the statute for that is 580.12. And in this case, because Anderson did not redeem the property within that time, she was completely divested of her interest in the real estate, and which it was then properly conveyed to Collection Resources and then to Rossman. So the court decided that in that situation, she has no standing to sue either of those two parties. And really the kind of key takeaway for this for the banks is the notice requirement for foreclosure proceedings. And so this case isn't precedential, but it's still enlightening to determine kind of how a court would think about it. And really the key takeaway is that you can just assume that the notice is received when it's properly addressed to the person and mailed, even if it's eventually, returned to the sender, as in this case. The second case I want to talk about is also foreclosure one, SW Partners v. Trade Center Property. So in this case, SW Partners lent out $1.8 million to two companies, MIG and TCP. These two were affiliates of one another, and the loan was guaranteed by the same person who happened to be the president of both companies. And it was secured by two properties, MIG property, TCP property. Both of them defaulted within a year of the loan. So after default, SW sued, seeking a judgment on the debt. And a month later, SW commenced two additional actions to foreclose on both properties. So that's kind of a key point here. There's three cases, all for one debt. MIG and TCP signed stipulations for all three cases, and they didn't contest how much was owed. They agreed to the amount that was owed, and they agreed to the foreclosure. So the court entered three judgments. One was for $1,983,000, one was for $1,990,000, the other was $2,005,000. And the reason the amounts were different was because of taxes. And after that, SW won a bid on the properties for $2.4 million. And eventually that left a surplus of $296,000, which MIG and TCP then wanted to have distributed to them, which SW opposed. And during hearing, the court asked SW if the judgment had been satisfied, which they said it did. And so then the court decided that MIG would receive surplus, and SW appealed that. So really the issue in the case is whether a surplus existed and whether it was owed to MIG. And in Minnesota, the statute for this is 581.03, which says that once a judgment is entered for this, the mortgage property will be sold and that amount will be used to satisfy the debt. And then under 581.06, if there's a surplus, it goes to the benefit of the mortgagor. So in this case, the court agreed with the district court, the Court of Appeals, and that they can't just ignore the other two actions. So it doesn't make any sense that there were three separate lawsuits, all for one promissory note. They should have been combined into one case, and it's not really clear why they were three different cases. But in any event, you can't have a multiple of three for the total judgment amount by having all these different cases when it's one debt. And it's very clear that the money judgment in the first case was satisfied, and SW admits that it was satisfied. So SW's real claim is about what constitutes the mortgage debt. And in this case, the mortgage debt is what the judgment amount was. So the court said that the stipulated judgment amount is substituted for the mortgage debt when determining the surplus. And that's why MIG and TCP were entitled to the $296,000 surplus. And there was a claim about equitable relief, but that was not very relevant to this discussion. So those were two kind of interesting foreclosure cases that came out that we wanted to make you guys aware of, and that I'll hand it back to Tess.
Thanks, Keith. Yes, that was moderately interesting. Super interesting for a banking lawyer, however.
Yes.
Fascinating. Will you stay on? I could probably use Tom too, because we're going to talk a little bit about fraud. We get a lot of questions. Keith takes most of them on fraud issues every day. Of course, you see that stuff every day. And those relate mostly to the UCC, which is enacted in our state statutes, but is a uniform law. So one this week, and maybe this banker's on here, I don't know, but here's one. We have a customer whose son held a party in their home. Remember this one, Keith?
I do.
Yeah, so somebody took a pad of checks. I've seen this before. And they forged a check made out for $3,000, and they did a mobile deposit of that into another bank. And the signature actually looked similar, which was kind of interesting. So makes you think it's more a son than maybe a friend. But I don't think my son could forge my signature very well at all. So it's interesting that it looked good. Interesting to me. Anyway, so the question was about the affidavit of forgery, because the customer called saying he didn't write that check. And the bank made up an affidavit of forgery for the customer to sign, but he doesn't seem to want to come in and sign it. So the banker's asking, can we send that affidavit of forgery to the police ourselves? How should we handle this? And, and who's going to take the loss on this? Well, obviously that check wasn't properly payable if it wasn't written by the drawer, or the owner of the account. And a person would have up to 1 year, an account holder would have up to 1 year to notify a bank that they didn't write a check. Of course, now you guys limit that in your account agreement, and the statute allows you to limit it. And some banks do 60 days, some banks do 30 days. 14 days has even been found to be reasonable by courts. In this case, I think it was 60 days, but they got in within the 60 days. And then we got into a discussion about, does a customer have to sign that affidavit of forgery? And what we have to say there is, I haven't seen a court case on this, but there are banks who say, if you don't come in and sign this affidavit of forgery, then we don't know that it's a forgery. We're not sure it's a forgery. So unless you sign this, we're not going to act as if it is a forgery, and we're not going to refund the money. Obviously, it's helpful in family situations where they don't want to deal with the police when they think it's a family member. So that was a recent question. It seemed like every question I pulled up really had to do about, with when you can return it. Here's one where we have a customer that we believe is being scammed by someone she met online. She's deposited a check in the past that came back as altered fictitious and lost some money, but didn't overdraw her account. So they closed that account and they opened her a new one. But now she's come back saying that check wasn't bad. It should not have been bad. And he's sending her more money to cover it. So one of those situations, that might be the dating one or something like that. He probably needs a kidney surgery is what I'm guessing. And if she could deposit that check and then send him some money for his kidney surgery, that's probably what is going to happen there. So yeah, it's totally a scam. So she's asking, do we have to deposit this check? I mean, we know this customer's been embroiled in this scam now. Do we have to even deposit it? We know it's bad. So my response was check the account agreement, because they usually reserve the right to refuse a check for deposit. Of course, we do see banks have to close customers' accounts when they refuse to accept that they're in this kind of situation. And then, they did that before and reopened one, but maybe next time they're not going to reopen it, because obviously she is falling victim to this multiple times. But then I also said, if this is a senior or vulnerable adult, then, a good option is to contact Marty Fleischecker of the Department of Commerce. We've had him on a couple of times on webinars, but he will call this lady and convince her that it's a scam. I mean, he's the best one I know at it. I mean, obviously it's hard for the bank sometimes to convince them, but Marty has had some great success in that way. So that is an option too. Keith, do you have any thoughts on those ones?
Yeah, I think that your points are pretty great on it. But a lot of the questions that we kind of been getting recently from bankers related to any unauthorized signatures on checks is that they're kind of surprised about the bank's liability for that. And so the reason that the bank that is the drawee bank, so your customer who has the check, you're the drawee bank, the customer is the drawer of the check. The drawee bank's responsibility is to check the signatures of the checks. Most banks don't do this. They just kind of accept the risk that perhaps a fraudulent check will come in here or there. But the reason that it's on the bank is because the bank is in the best position to check that the signature is valid. And so on the unauthorized drawer's signature, that is why the liability lies with the bank. Another issue that we've had come up is when some people have been calling in or emailing us and they have been kind of confusing an altered check with an unauthorized check. And an altered check is different. These terms are defined in the UCC and it's not the same. So the liability for an altered check usually lies with the bank that it was deposited into, and then any transferring bank to the drawee bank. So the UCC has presentment warranties, which is when the check is brought to you to pay. It is presented to you and you pay, and there is a warranty that it hasn't been altered. And it has been, and there's the same with transfer warranties for any banks in the line between where it was deposited and to where it's going to get paid. So they warrant that it hasn't been altered because they are in the best position to determine whether or not the check has been altered in any way and whether or not there's some sort of wrong, signature or payee on there. So the liability would usually lie with a depository bank in that situation. So those are different, but we do have a compliance guide that Tess pulled up for forgeries that should be pretty helpful for people as kind of a refresher on this subject.
Yeah, that's on our website under the legal tab. We have a bunch of these compliance companions on different topics, but this forgery one is really good, and it's going to cover alterations, forged jar signature, forged endorsements, and just gives you quickly what the rules are regarding all of those. The rules Keith is talking about are old. I mean, that's why I think bankers have a hard time dealing with. I mean, it shouldn't be a dry bank's fault, right? We don't look at signatures, whatever, but loss has to be allocated. And that was the decision that was made long ago by probably the Uniform Law Commission. So that's just how it works. You may not be checking signatures, but you're the only one who could check signatures. Same on the depository side. You're the only one who could make sure that that endorsement on the back of the check is legitimate. The drawer bank can't do that. So that's why that got allocated that way. Also, we have a ton of information about this stuff in our deposit manual. I know when Keith gets questions, he always gives them information from our manual. So that's a great resource too. There's a whole chapter on this stuff. I think that's all we've got today. Tom, do you have anything to add?
No, I don't. Just it's interesting. That's not related to checks, but wires. It's kind of similar. A lot of the courts look at the bank as the last line of defense for sending a fraudulent wire transfer. So even if the terms of their wire transfer agreement with a commercial customer say it's supposed to be sophisticated, the bank will be left holding the bag.
Yeah, it's not about fairness, really, is it now? All right, well, I think that's all we've got. If we had one question about the legislative summary, how can they get a copy? You would just print it. We have it online as well on our, I think, our advocacy tab on our website, but we don't print those anymore. Too many trees killed, I guess. So if you want to print it, feel free. I think that's all we've got. If you have any topics you want us to cover for our next Minnesota Matters, just let us know, and any of us know, and we will certainly look into covering those. Thanks for joining us today, and I hope you have a great day.